Morning, everyone. Welcome to day 2 of the 6th Scottish Conference. Yesterday was a very full day in which we covered a very wide range of topics, and I think today will be no different in that respect. We have 3 panels today on strategy and institutional interactions, the ICJ and time, before we have a panel on the ICJ and genocide. We will get started in a moment, just to say that we will, for the participants, try and do a group photograph at the coffee break. But for now, I'll hand over to my colleague, Dr. Joseph Crampon, to kick us off with the first panel of today. So thank you.
Thank you, James. Yeah, I'm Joseph Crampon. I'm a lecturer here in international law at the University of Glasgow. And it's my pleasure to convene this panel of very interesting and I think timely papers on questions of strategy and institutional interactions in relation to the ICJ. The first paper is by Veronica Botticelli. She's a postdoctoral researcher at the University of Milan. And her paper will be on the title of More Foes Than Friends, the ICJ's enduring struggle with CERD's procedural and substantive requirements amidst multi-forum litigation on racial discrimination. So, Veronica.
Okay. Good morning, everyone. First of all, many thanks for being here and many thanks for having me. Before even starting with my presentation, I would like to thank the masterminds of this conference, Professor Christian Tanz, Professor James Devane, as well as Martina and all other people involved in the organization, for having put together such a brilliant program and for giving us the opportunity to share some reflections about the 80th birthday of the ICJ. Speaking about anniversary, I will focus on my attention on the presentation looking at the way in which the ICJ interprets and applies a core human rights treaty, which has been progressively more and more invoked before the ICJ, and quite ironically, which also will blow its candles in 2025, which is the International Convention for the Elimination of All Forms of Racial Discrimination. I don't know what's happening. Okay, it should work. Most notably, as you can see from the slide, I would like to expand on a rather rhetorical question, given the recent case law that is does the ICJ has proven to be a good venue for CERD-based claims, or rather has been more a foe than a friend to the CERD, and especially with regard to its engagement with the CERD committee? We will touch upon some of the questions you can see from the slides, but before digging deeper, I would like to have a brief overview of the ICJ attitude towards the decision of other courts and tribunals, because over the years, the ICJ has liked to remark its own centrality in the ICT's galaxy, especially in the wake of the fragmentation of international law, which, as all of us know, has brought to life different self-contained regimes. And this regime seems to revolve around the sun, that is the World Court. Here, I think it should fit the statement of the then president of the ICJ, Judge Guillaume, who, addressing the UN General Assembly in 2000, he said, and I quote, "The proliferation of international courts give rise to a serious risk of conflicting jurisprudence in different cases, and a dialogue among judicial bodies," and I underline judicial bodies and non-quasi-judicial bodies, "is crucial. The ICJ, the principal organ of the United Nations, stands ready to apply itself to this end if it receives the necessary resources." Let's not focus on the source issues, which is currently a hot topic within the UN system as a whole, but the statement is telling about the ICJ's self-perception of the chief judicial organ of the international legal system. Through both separate and dissenting opinion, as well as declaration, and we stressed yesterday the value of individual opinions, several judges have over time reiterated the centrality of the ICJ. However, has also draft conclusion 13 on the ILC work on customary international law reminded us decision of the ICJ, as well as those of other tribunals, can contribute to the reconstruction of customary norms. Over time, the ICJ has demonstrated not to be locked in an ivory tower, although it historically mostly cited itself. At times it considered external precedents for various purposes and trying to draw a taxonomy, let's say, of external precedents. Of course, they are used for different purposes. Perhaps all of us can recall the ICJ's posture vis-a-vis the case law of the ICTY in the Bosnian genocide case, where the ICJ distanced itself from the overall control test, claiming for the stricter effective control rule. In a more positive note, as we can see like from cases like Diallo and the Wall opinion, the ICJ has explicitly cited the views of some human rights bodies, such as the Human Rights Committee, or at times also the African Commission of Human and People Rights, to inform the interpretation of the treaty instruments at stake. Did the ICJ do the same as regards the CERD committee? Short answer is not really. As we can see here, a switch from some sort of formal deference to external precedents to a general disregard of what should be conceived as the chief monitoring treaty for apply and interpret the CERD Convention. Unpacking this further, we should consider as a point of departure two sets of provision which the ICJ has been recently asked to interpret and apply, and I'm talking first of Article 1, Paragraph 1 of the CERD, which is the substantive provision laying grounds for discrimination. And on the other hand, we are talking about the norms which establish some sort of control or monitoring vis-a-vis the state's obligation under CERD. First of all, Article 1, Paragraph 1 has no sets the ground for racial discrimination. Many scholars consider Article 1, Paragraph 1 to be a numerus clausus, and the CERD define racial discrimination for the purpose of Article 1, Paragraph 1 as, and I quote, distinction, exclusions, restriction, preference based on race, color, descent, or national or ethnic origin, which has the purpose or effect of nullifying or impairing the recognition, enjoyment, or exercise of human rights and fundamental freedom. As for the procedural provisions, we have like a two-tier interstate mechanism, not considering here Article 14 that establish individual complaint mechanism. Article from 11 to 13 provides for a compulsory interstate communication mechanism, which led to a conciliation between the parties before an ad hoc conciliation commission, which can be established under the convention. On the other hand, we have Article 22, which mirrors the classic compromissory clause before the ICJ, granting the latter the jurisdiction for contentious cases to interpret and apply the convention. As for the substantive question, that's where the trouble begins, because out of all 5 cases ever brought before the ICJ under CERD, only one reached the merits, which is Ukraine versus Russia recently, and we will dig in it in a minute. But already in the preliminary objection phase, the ICJ has proved to adopt an over-restrictive approach to racial discrimination on one of the most pressing issues, which is discrimination based on nationality versus discriminations based on national origin. In the Qatar case, the ICJ held that racial discrimination prohibited by CERD should be disconnected with national origin insofar as national origin can be considered as an inherent bond attached to each person at birth, contrary to nationality, which, as we all know, can be acquired. Here, the ICJ adopts a radical different position from the CERD, insofar as it cites General Comment number 30 of 2004, but it distanced from it. Also, General Comments number 30 posits, and I will quote, under the convention, differential treatment based on citizenship or immigration status will constitute discrimination if the criteria for such differentiation, judged in the light of the objective and purpose of the convention, are not applied pursuant to a legitimate aim and are not proportional to the achievement of this aim. Moreover, and more radically, the ICJ replaced the CERD committee position expressed in Qatar versus UAE, where the claim had been considered admissible ratione materiae before states reached an agreement to solve the dispute. More recently, the ICJ added another brick to its hyper-formalist approach to Russia discrimination in the context, as we were saying, of Ukraine versus Russia, brought under CERD and under the International Convention for the Suppression of the Financing of Terrorism. Here, by a majority of 10-5, the ICJ found that any discrimination treatment or effect suffered by Crimean Tatars and ethnic Ukrainians was a result of their political and ideological position and was not related to prohibited grounds under Article 1, Paragraph 1 of CERD. Here, in this case, Ukraine argued that Russian anti-extremism law disproportionately harmed Crimean Tatars and ethnic Ukrainians, leading to the ban of the mailis. The majority of the court was unconvinced because the court said that this measure targeted political or ideological position and not ethnic origin per se. Here, separate opinions once again told a different story because we have Judge Donahue pointing to the risk of vague and formally neutral anti-extremism law, which can have adverse impact. We have Judge Charlesworth emphasizing that once the discriminatory effect is demonstrated prima facie by the applicant state, the burden of proof should shift to the respondent state to justify that the measure, which is formally neutral, has been adopted or implemented with a discriminatory purposes. Finally, Judge Adok Pokar reminded that CERD does not require intent, so neutral law can still be discriminatory in effect. Here in Ukraine versus Russia, the ICJ, according to me, missed a real opportunity to align with CERD more progressive standards, somehow raising the bar for application in alleging racial discrimination claims and leading to what I define a genocidification of CERD. This is somewhat worrying because, like, some authors also label CERD as an alternative convention to invoke instead of the Genocide Convention, which, as we all know, has been interpreted in the past by the ICJ as requiring somewhat a probatio diabolica of mens rea. But here's the difference, because as we know, in the Genocide Convention, mens rea is explicitly required, and in the CERD Convention, she's not there. In Azerbaijan versus Armenia, we have, I don't know, I lost my track. Okay, in Azerbaijan versus Armenia, things got perhaps worse, even if confined to some procedural features of the CERD Convention. Here, the court reiterating its findings about the relationship between Article 11 and 13 and negotiation conciliation as alternative precondition for sizing the ICJ. The ICJ added another brick to this reasoning, shedding some light or perhaps some darkness, as we will see, about the interplay, if any, between the interstate communications procedure and the compromissory clause, which is an issue which has not been really dealt in previous cases, such as Georgia versus Russia and the Qatar case. Here, the ICJ in Azerbaijan versus Armenia adopted a posture that might seem a bit Sibyllin and partly incorrect, because it labeled Article 11 to 13 procedure and the correspondent CERD committee quasi-judicial competence as monitoring state compliance. In doing so, it seems to conflate the main non-judicial feature of the CERD committee, which is periodic state monitor, with a quasi-judicial feature of the committee that is addressing complaints. Moreover, here the ICJ reached this confusion, which is troubling, without really engaging with the CERD committee, where it recognizes in some decision that its procedure is, of course, not binding, but is more than mere monitoring. Here, in this context, Judge Cleveland's separate opinion actually reignited an old debate. Yes, an old debate, because she questioned the ICJ's fuzzy approach to the issue and to the concept of a dispute under the CERD Convention. The ICJ here seems to reinforce the two-tier CERD control mechanism insofar as while for the purpose of articles from 11 to 13 of CERD, proceeding can cover any temporal period when the respondent state has obligation under CERD, while Article 22 as a dispute settlement mechanism require the existence of both bilateral relationship between states. Here, it seems like the CERD provides for two containers, different in aim and structure, of course, for the same content, that is dispute regarding the application of Erga Omnes Partes CERD-based obligation. And in this regard, and I will conclude, talking about Erga Omnes, in brackets, partes nature of CERD, Azerbaijan versus Armenia has tackled the question under the prism of jurisdiction ratione temporis, which has been interpreted in a very peculiar way, because in the Azerbaijan versus Armenia case, we have the claimant state, Azerbaijan, that alleges facts and violation occurring before the establishment of mutual relationship between the parties. Here, disregarding the CERD committee view in Palestine versus Israel case, as well as disregarding or not engaging with Austria versus Italy before the European Commission of Human Rights, the ICJ basically inserted a requirement which is not widely expressed in the convention, which is to confine the application of the CERD solely from the moment of the entry into force of bilateral relationship between the parties. Here, the ICJ, quite interestingly, seems to have overruled the Bosnian genocide case, but in a rather disguised manner, because it seemed also to resurrect some Botticelli's reasoning, cautiously not overruling, but distinguish it from the case at hand. To conclude, it is evident that the CERD and the ICJ has not get along so far, and perhaps prospective applicant states, on the basis of the outcome of Azerbaijan versus Armenia case, if they want to continue pursuing the ICJ route with the CERD, they should probably frame themselves as both Omnes and, where feasible, directly affected parties in order to overcome the difficulties, insofar as the main lesson we can learn from Azerbaijan versus Armenia is that the ICJ, perhaps in order to overcome the increasing number of Erga Omnes Partes obligation, seems to have left for a future debate the fact that maybe Article 42 states that Article 48 or Article 42 of RCEWA and Article 48 RCEWA claimant state could be placed in the same position for future cases. With this, I conclude, and I'm hoping for a debate.
Thank you very much, Veronica. Next, we have Hoon, who is a senior researcher at the Korean Institute of Ocean Science and Technology, and it's also a pleasure to welcome Hoon back to Glasgow, where he completed his PhD. I'm not sure how many years ago, but I don't think we overlapped, but certainly welcome back, Hoon, and please come and speak about the concept of abusive process in advisory proceedings.
Well, good morning, everyone. My name is Hoon from Korea Institute of Ocean Science and Technology. And first of all, I'd like to express my huge gratitude to the organizers for giving me an opportunity to have a presentation to this wonderful event. Also, I feel very pleasure to be back to my academic hometown. I could meet many colleagues from my old times, and also what makes me more exciting is that actually I'm standing in front of my former supervisors. So actually two supervisors here and there. So it feels me like having another extended supervisory session. So please, be generous on my research, please. So anyway, I'm gonna enjoy this moment. So today I'm gonna suggest some theoretical component to be determined as an abusive process. And many of you are well aware of, there have been some allegations that there are some abusive process cases with regard to the ICJ advisory opinion proceedings, while the ICJ has never accepted such allegations. So in this presentation, I will consider this term, the abusive process, as a legal concept, and I will examine the applicability of my suggested component to the actual ICJ advisory opinion proceedings. So let us first check when such allegations were made. So here is a list of a total of 31 ICJ advisory opinion case brought before the ICJ. And as you can see, in 4 of these cases, the allegations about the abusive process of the advisory opinion of the ICJ has been raised. And these cases were the legality of the trade or use of nuclear weapons case, the Palestinian or Israel construction of the wall in the occupied Palestinian territory case, the Chagos case, and also the policies and practices of Israel in the occupied Palestinian territory case. And as you can notice, all these cases were brought by the General Assembly of the United Nations. So let us bring back to the first slide. So in all these cases, the main subject matter of the request concerned the internationally sensitive issues involving diverse interests of states. Moreover, these allegations assume that examining the requested issue in the advisory proceeding is no different from making a ruling on those issues. Let me correct one thing. When I said that these allegations were made in these 4 cases, that allegations were from the either written or oral statement of the state parties or the minority opinion of the judges only, excluding the academic opinions. So hence, they also point out that these cases would deprive interested states of their opportunity to seek a resolution by using their agreed means. Then let us check the context and background of these allegations. First, until the 1980s, 13 out of 20 cases were related to the functioning of the authorized international bodies. However, from 1990s, most of the cases, the topics of the most of the cases have become diversified, dealing with complex and sensitive issues that were once considered as a subject matter of the long political negotiations. And it is also very interesting to note that most of these cases were brought by the General Assembly of the United Nations. Second, we must note some certain legal effect that the advisory opinion of the ICJ may have. Of course, yes, advisory opinions are not binding, but when the court addresses a legal issue, providing an advisory opinion would have a certain impact on the overall progression on that issue as well. And in this context, it is very interesting to note, to see the Article 102, paragraph 3 of the rules of the court, which regulate that the judge ad hoc system can also apply to the advisory opinion proceedings under certain circumstances. Third, also, we should consider about certain difficulties in seeking to resolve a dispute through the adjudication as well. When seeking to resolve a dispute through judicial procedures in international relations, as we all know, there are many hurdles that must be satisfied or met. But it can be considered that such hurdles can easily be overcome by using or by taking the way of advisory opinion proceedings. Lastly, the so-called advertising effect. of putting an issue on the general list of the court should be noted as well, because the fact that ICJ will consider a certain legal matter anyway can attract much international attention on that issues. This indicates that the involvement in the general list may have certain effect of political exploitation of public attention on the question at issue. So based on this, let us move on to some theoretical components to be determined as an abuse of process. So as a first requirement, I suggest the wrongful invocation of procedural rights. The conceptual origin of the prohibition on the abuse of process is the principle of good faith, which protects the legitimate expectations of others by protecting the common interest from excessively individualistic claims. Since this principle prevents drawing benefit from wrongful actions, the abuse of procedural right conversely presupposes that certain procedural rights are unlawfully invoked. So basically, an abuse of process occurs when a right to judicial or quasi-judicial procedure is interpreted or applied in a way that does not conform to others' reasonable expectations of how that right or procedure should be invoked. As a second requirement, I suggest the existence of malicious intention. The absence of good faith or not acting in good faith implies a bad faith, which means the fraudulent motives or injuries or arbitrary intentions. In fact, there are some commentators' view that such a subjective element is not essential in determining the abuse of right. However, I think that if malicious intent is acknowledged along with other factors, then the determination of a certain act constitute as an abuse of rights can become much clearer. And similarly, if a party to a dispute resort to an international court to acquire any undue advantage over the disputed issues, this may indicate any clear underlying malice. The last component that I'd like to suggest is the consequential element that may arise from the wrongful invocation of procedural rights with malicious intention. This component aligns with the element of injury in determining an abuse of right. And unlike the second element that I have just suggested, many authors also consider that this is a fundamental element in applying the principle of prohibiting the abuse of rights. So in the context of procedural matters, an impact that interferes with the proper functioning of the judicial system can be considered as an injury resulting from an abuse of procedural rights. And the ICJ has also emphasized that the integrity of its judicial function must be protected, and this may act as an inherent limitation on its exercise of jurisdiction. Then what is the legal consequences of finding abuse of advisory proceedings? When you apply the component that I have suggested to the ICJ's advisory opinion process, first, if the requesting body does not meet the procedural preconditions or jurisdictional requirements for requesting an advice opinion, and second, if there is a harmful intent to cause any injury or to gain an undue advantage over a certain issue, and lastly, third, if it is expected to have the effect of undermining the proper functioning of the ICJ's advisory opinion system, then we can say that such a request may constitute an abuse of process. The abuse of process concerns the question of judicial propriety, which is, when it comes to the advisory proceedings, is relevant to the court discretionary power. So, the legal consequence of an abuse of ICJ's advisory opinion proceedings will be that it constitutes the compelling reason leading the court to refuse to respond to a suggested request. In addition, I have no doubt that this will also lead to a deficiency in jurisdictional basis because, as I suggested, the wrongful invocation of procedural right constitutes the very first component to be an abuse of process. So now let us bring this component to apply to the actual ICJ advisory opinion proceedings. And this will show some hint concerning the likelihood that a certain case could be ruled as an abuse of process by the ICJ in the future. And to conclude first, due to many difficulties, the ICJ's reluctance to find an abusive process is likely to persist in the future. So, the first component was the wrongful invocation of procedural right by not satisfying the jurisdictional requirement. When it comes to the General Assembly, which is most relevant to the alleged abuse of process case, the only substantive requirement is that they may request advice opinion on any legal questions. However, according to the jurisprudence of the ICJ, the scope of the acceptable subject matter of such legal questions seems to be very broad. For example, in the Western Sahara case, the ICJ stated that there was nothing in the Charter or the statute to limit the competence of the General Assembly to request an advisory opinion. Moreover, the ICJ has confirmed that even if there are political aspects within a question, it does not suffice to deprive that question of its character as a legal question. So this demonstrates that it is quite difficult to expect the ICJ to deem a certain request as not legally constructed one, even if it pertains to internationally sensitive issues or the pending dispute as well. Yes. Then let us move on to the second component. The second component was the existence of malicious intent. The ICJ has been generally reluctant to accept the objections made based on the underlying motivation. And for instance, in the Kosovo advisory opinion case, the ICJ stated that in determining the jurisdictional issue of whether it is confronted with a legal question, it is not concerned with the political nature of the motives which may have inspired the request or the political implications which its opinion might have. Well, such a negative attitude may be due to some practical difficulties in finding malicious intent. First, in order for the court to find such a malicious intent, the ICJ must determine whose intention is the primary motivation for asking for an advisory opinion. As we all know, the process of adopting a resolution in the General Assembly for asking an advisory opinion from the ICJ, this involves many actors, like a proposing state, as well as a sponsoring state, and even Secretary General of the United Nations. But the problem is that it is quite difficult to determine whose intent is dominant for determining the intent of the requesting body. Secondly, moreover, even if we can specify who was in a dominant position, we always, we should note that there can be many or multiple reasons behind the make a request for an advice opinion. But any confirmation of the intent is inevitably based on subjective speculation or presumption because except the proposing state or the sponsoring state themselves, we cannot be certain what is the real or the true motivation is. So these are the practical difficulties in finding some intent. Okay, so the third component is the undermining effect on the proper functioning of the advisory opinion system. And here I'd like to suggest the circumventing effect of the principle of consent on disputed matters can be a relevant one. The position of the ICJ is that providing advisory opinions without the consent of the interested state is incompatible with its judicial character of the court because of the effect of circumvent the principle of consent. But in practice, the ICJ considered that providing an advisory opinion did not substantially disrupt the principle of consent. And there are some common reasons or excuses that the ICJ has repeatedly relied on. First, the ICJ considers that the principle of consent applies only to contentious case where this principle constitutes an essential basis of the court's jurisdiction. Second, according to the jurisprudence of ICJ, ICJ considered that the court's response to the submitted question is only advisory in nature and has no legally binding force. Third, the ICJ also considered that no state can prevent the ICJ from issuing an advisory opinion, which the authorized organs deem desire to obtain from the court. And lastly, the court's opinion is given to the organs entitled to request such a question, but not to the state parties. So from these attitude, we may say that it is highly unlikely that the ICJ will ever find that issuing an opinion on a disputed issue would result in circumventing the principle of consent and thus undermine the proper functioning of the ICJ's advisory opinion. So, lastly, I'd like to wrap up my session with some few remarks. So, the advisory procedure of the ICJ is not a form of judicial resolution for states. However, the ICJ has engaged in many cases dealing with politically sensitive issues, attracting much international attention. In this regard, it is even argued that it has become a positive trend that the ICJ is getting involved in matters with politically sensitive questions. And one judge of the ICJ has described that the concept of abuse of process has become the holy grail of international law due to the total absence of a definitive description or inventory of its content. However, I think that even if a theoretical definitive description or inventory of its content is given, I'm very doubtful whether that the ICJ will become more active in acknowledging the abuse of process cases in the future. And one of the reasons is the practical difficulties that I suggest today. So this is the end of my presentation. And thank you so much. And please give me many insightful comments and questions to help me to develop this ongoing research. Thank you very much.
Thank you very much, Hoon. Next, we turn to Anagnostopoulou from the National Kapodistrian University of Athens. Faye is an LLM candidate there, and she'll be speaking about comparing the ICJ's advisory opinion and the CERD Ad Hoc Conciliation Commission's decision on Gaza towards a judicialization of the Israel-Palestine conflict via strategic means of dispute settlement before the UN system. So, Faye, over to you.
Okay. Thank you, Joseph, for the introduction. Before I start, I just briefly like to thank the organizing committee for allowing me to present my paper, despite not really qualifying as an early career scholar. And this paper was originally drafted for a student competition hosted by the Göttingen Journal of International Law. So one thing in the limited number of conferences I've attended, one thing that I don't really like is that when the speakers in the panel, they don't interact with each other. So I really hope that this presentation actually serves as a bridge, not only to what we've heard from the two previous speakers, but to some points made yesterday. For instance, the ICJ avoiding, and other organs avoiding clearly commenting upon specific issues, and also the limit and the restriction between the judicial function of the ICJ and high political matters. So with that in mind, today we'll be comparing the ICJ advisory opinion on Palestine and the decision of the Ad Hoc Conciliation Commission operating under the CERD framework, both delivered in 2024, as strategic means of settling the dispute before the UN system. Okay. Okay. Now it works. Sorry for that. So I would firstly like to place the two rulings within the broader context, not only of the dispute, but of recent state practice relevant to lawfare and the strategic utilization of different legal and judicial avenues. So I don't want to thoroughly examine the overall UN's involvement in settling the dispute. Where I want to focus is the recent wave of judicializing the Palestine dispute that we have been witnessing the past decade. And as you can see, I've tried to map some of the efforts to judicialize the dispute in various judicial organs within or outside the UN system. So we've witnessed 3 advisory opinions on issues of Palestine, 3 contentious proceedings involving, in one way or another, the situation, ICC open investigations, and again, last year it issued arrest warrants against Israeli prime minister and high officials. And in 2018, Palestine itself enacted for the first time actually in history the CERD framework. Just a clarification here, the CERD framework as described by Veronica has also been utilized by other members, for instance, Qatar and UAE. However, the case of Palestine was the only one that led to the establishment of an ad hoc Conciliation Commission. Therefore, there lies the, let's say, important procedural and substantive aspect of this case. So although it is very hard to map the exact motives behind each and every of those applications, they're definitely placed within the broader context of strategically utilizing judicial organs in order to receive authoritative or sometimes binding pronouncements on different issues on the Palestinian question. So, okay. So why I have specifically chosen the CERD and the ICJ decisions to compare? First of all, because there are two procedures offered within the wider system of the UN. There are two procedures offered within the wider UN system. I think it's self-explanatory. I don't need to delve into the ICJ statute on its advisory jurisdiction. However, just a small note, all UN treaty bodies operate under the supervision and support of the UN High Commissioner for Human Rights. Therefore, that's why I consider it to be placed within the broader UN system, exceeding the strict limits of the Charter. Secondly, they don't have an adversarial character, meaning that they're not stricto sensu litigation means. Thirdly, they are the only rulings we have on racial segregation and apartheid, which is quite important. And fourthly, and in my opinion, the most interesting part about them is that they're not binding. So the two questions I will try to answer today is, first of all, what are the procedural advancements these two procedures offer, not to Palestine or any other state wishing to utilize them, and secondly, how do they actually contribute to settling the dispute? And, oh, sorry. Okay, now I've spoiled everything. It's okay, sometimes technology fails us. Anyhow, so the comparison will take place, will be twofold. First of all, I will look at some procedural hurdles, focusing mainly on Israel's non-consent to those procedures. And secondly, I will delve into some substantive issues relating to the authoritativeness of those rulings and their practical implications. I'm sorry. Okay. So a point of debate in both proceedings was Israel's reluctance to consent generally. However, the jurisprudence of both organs has evolved in a way that Israel's non-consent would not ultimately obscure the issuance of the rulings. And in my opinion, here lies the strategic advancement offered not only to Palestine, but other states wishing to utilize these procedures, that state consent is not or may not be a very difficult obstacle to bypass. So let's focus first on the CERD because things there are a bit more straightforward. On the committee's response to Israel's unilateral statement excluding treaty relations with Palestine was twofold. First of all, it stressed the functional link between the jus cogens norms and the Erga Omnes obligations established thereto, and the Convention's enforcement mechanism, which is tailored to the CERD's special and collective character. The committee, in contradistinction to the recent order the ICJ delivered in the Sudan versus UAE case, did not isolate the procedural mechanism, but construed it as a necessary way of realizing the Convention's object and purpose, which was established for the protection of collective interests and therefore requires collective action when it comes to enforcement. And secondly, as Veronica mentioned, it highlighted the unique element of the procedure, which has the unique nature, which has two elements. First of all, it is automatic, therefore it does not depend, meaning it is not optional, as for instance to the procedure offered in the Torture Convention. And secondly, it is conciliatory, which means that it needs to be effective. And as a result, it cannot depend on the unilateral will of states to be enacted. So the CERD, following the extensive jurisprudence of either treaty bodies and regional human rights courts, seems very progressive and very eager, at least procedurally, to uphold the Convention's object and purpose. Now, on the other hand, the ICJ's approach is a bit more restricting, one would say, because the ICJ has been entrenching state consent not as a matter of jurisdiction, but as a matter of propriety. And the approach of the ICJ, although it leads to the same conclusion, it did issue the rulings, in my opinion, is troubling for two main reasons. First of all, because entrenching state consent as an admissibility barrier is premised upon a very, very old judgment of the PCIJ, known as the Eastern Karelia case. I don't want to bombard you. I mean, I don't have time to bombard you with facts on the Eastern Karelia. However, the rationale of that case is so narrow and so limited that it cannot be applicable to the UN system, where all states are members of the UN and have therefore recognized the advisory jurisdiction of the court. And we cannot deduce from Eastern Karelia general pronouncements on the bilateral character of disputes and state consent, exactly because the case was very, very limited. And secondly, it recycles a very old-fashioned perception of international law as having a strictly bilateral nature. Because again, if we see the reasoning the court gives why state consent, Israel's consent in this case, does not bar it from issuing the opinion, it emphasizes on the institutional role the UN plays in settling the dispute, the Palestinian question, rather on the jus cogens and erga omnes nature of the obligations that are actually at stake. And, you know, as Judge Studi in his opinion said, that the court seems very indulgent when it comes to matters of propriety, and it really shouldn't. Okay. So you can tell that we don't have these in the university. Yeah. Now, moving on to this, which is more interesting in my opinion, but equally sensitive, is the non-binding nature. Okay, so we managed to bypass Israel's consent. What about it? The decisions remain strictly sensual, not binding. However, as the ITLOS has recently clarified, they have an authoritative nature. Or for the Ad Hoc Conciliation Commission, clarification again, now you see I'm referring to the Conciliation Commission and not the CERD committee, because once the committee found that Palestine submissions were admissible, then they moved on to establishing the Conciliation Commission, which was the one to issue the full report. So again, the ICJ has referred, as Veronica said, to the work of human rights bodies, giving them important legal weight. And the ILC, in its very recent work in draft conclusion 10, it has recognized that the work of human rights bodies can serve as secondary source of international law. Therefore, based on that, we see that there is, let's say, a scale of measuring the legal relevance of different legal documents. Obviously, at the top, we have judgments, which are binding. But what does it mean that they are binding? In my opinion, their bindingness is an element that somehow comes from the outset of the decision, meaning that states have previously agreed that the decisions are going to be binding and we have an obligation to abide by them. Therefore, the bindingness does not necessarily depend on the content of the pronouncement made in a judgment. And secondly, they seem to be enforceable, but as stressed yesterday by many speakers, they're not really that much enforceable. Now, on the other hand, the pronouncements made by the ICJ in advisory opinions, and I think the same can be applicable to the ad hoc decision, is that their bindingness from within, in the sense that they reflect the current state of international law that Israel must adhere to, irrespective of the issuance of an advisory opinion or not, because the rules of international law are ipso facto binding, whether the ICJ agree, Israel agrees to the jurisdiction of a court or not. And secondly, they come from organs that have high legitimacy. I mean, we're talking about the principal judicial organ of the UN and an ad hoc commission that is composed of CERD members who are, let's say, the experts in interpreting the CERD convention. And both of them, they followed a very strict procedure and came to the conclusions with absolute rigor and scrutiny. So although I don't have time and I'm willing to have a more wide discussion on that in the Q&A, Judge Nolte has a very interesting point in his dissenting opinion in the Palestine case, where he distinguishes between legal characterization made in advisory opinions and legal determinations made in the judgments. However, this distinction, in my mind, is very artificial and cannot be applied in this case, in the Palestine case, for the very simple reason that in the advisory opinion, the ICJ has made legal determinations as to the state, as to the responsibility of Israel, because if I'm not mistaken, in paragraph 267, the ICJ unequivocally says that Israel has committed internationally wrongful acts and is therefore responsible, and even it has clauses on reparation. Therefore, in that specific case, I think we extend the strict sense of legal characterizing the situation in Gaza. We are making determinations that are going to be of use. No? Yes, that are going to be of use to those who will make the decisions. And saying that I'm right now using my time, but just a very quick comment so that I conclude. And yes, so my point is that these procedures are not going themselves and per se to solve such high political and deep-rooted dispute. However, the Chagos demonstrates an excellent example of how the pronouncements are an indispensable part in a chain of events that will ultimately lead or will influence or will set the legal frame within which a decision, a political decision, always will be made. And I think that is their contribution and their stance in the dispute settlement system outlined in the Charter, that they constitute manifestations of the peace through law doctrine, which is the foundation of everything that we have today. So, thank you.
Thank you very much, Faye. Certainly in terms of papers speaking to each other, I think obviously talking about CERD and advisory proceedings relates back to the first two speakers, but it also, you mentioned Erga Omnes, which leads us to the last of our speakers, who is Priya from University of Oxford, where she is a junior research fellow at St. John's College. And she'll be speaking on the articulation of Erga obligations, Erga Omnes, and Erga Omnes parties by the ICJ, coherence or confusion. So, Priya, over to you.
Good morning, everyone. Thanks, Joe, and thanks also to Christian and James for having me at this really wonderful event. So as the title of the paper suggests, it essentially looks at how the ICJ understands and identifies obligations erga omnes and erga omnes partes. And I had sort of two main motivations for writing it. The first was that it seemed to me that today a wide variety of obligations are described as obligations owed erga omnes or erga omnes partes, but without sort of sufficient or sometimes even any explanation as to why or on what basis. And even though the conceptual foundations of these obligations were discussed in the context of the ILC's articles on state responsibility, the Commission didn't really give us any sort of definitive explanation other than what we can now sort of glean from Article 48 of the articles and the various reports of the Commission. And my second motivation for writing the paper was concern for the significant consequences that follow the characterization of an obligation as erga omnes or erga omnes partes. So specifically the entitlement to respond to breaches of these obligations, even in the absence of injury on the part of a state. So whether through adjudication or through various unilateral measures, such as countermeasures. And since the ILC's articles were adopted, the position that the ICJ has taken is that the general requirement of standing on the part of a state instituting contentious proceedings before the court doesn't apply when the breach of an obligation erga omnes or erga omnes partes is at issue. And so by relaxing the requirement of injury in these cases, the ICJ has opened the door to what many would now refer to as public interest litigation or litigation in the collective interest or the common interest. And this is quite a significant development. So for these reasons, I think it's quite important for us to understand what it is that makes an obligation owed erga omnes or erga omnes partes. Two of my co-panelists have already referred to the erga omnes partes character of some of the obligations in the CERD. So I think, those are just examples of why it might be useful to clarify. And so what I'll do with the rest of my time is first set out what I argue in the paper are essentially three broad approaches or rationales that the court has used to support its characterization of obligations as erga omnes or erga omnes partes. And second, to make some observations as to what are the consequences of adopting these three approaches, which so far the court hasn't done very deliberately or very consistently. And at times these approaches have also been applied together. So all in all, not a very clear picture. So looking at the case law of the ICJ, the first approach, which is also the most common approach, is to identify obligations erga omnes and erga omnes partes by reference to the collective interest of all states or of a group of states, respectively, in compliance with the obligation in question. And so as we know, it was in the Barcelona traction case that the court described obligations erga omnes as obligations owed by a state to the international community as a whole, and in whose performance all states can be said to have a common interest. Now, this idea that states can share a common legal interest in compliance with certain obligations was actually seen earlier in the Southwest Africa cases as well, notwithstanding the fact that the court ultimately dismissed those cases. And this language of common interest has been recalled a number of times by the court, including in the Wall and the Wall and the Chagos advisory opinions, and also more recently in the Occupied Palestinian Territories advisory opinion last year. Remarkably, I think in some ways, the recent climate change advisory opinion also uses this approach. So in the climate change opinion, the court declared that all states have a common interest in the protection of global environmental commons, like the atmosphere and the high seas. And on that basis, it characterized various obligations giving effect to this shared interest as obligations erga omnes. This reference to the common interest is also seen in the ICJ's approach to obligations erga omnes partes. And so this language is actually seen in all of the cases in which the court has affirmed the standing of a state, even in the absence of injury. So in Belgium versus Senegal, for example, the court engaged in an exercise of treaty interpretation and invoked the object and purpose of the Torture Convention to suggest that each state party has an interest in compliance with the obligations erga omnes partes contained in the treaty. And the same approach was taken in relation to the Genocide Convention, both in the Gambia versus Myanmar, and also when the court first indicated provisional measures in South Africa versus Israel. Likewise, again, the Climate Change Advisory Opinion also referred to the preamble to the UNFCCC and the Paris Agreement, which each described climate change as a common concern of humankind, in order to conclude that these treaties comprise obligations erga omnes partes. So much for the first approach. The second approach of the court also finds its roots in the Barcelona traction dictum. And in that case, it was the importance of the rights protected by relevant obligations that led the court to conclude that all states must share a common interest in compliance with these obligations, which are owed erga omnes. And so this justification supported the court's characterization of the prohibition of aggression, the prohibition of genocide, various human rights obligations, including the prohibition of racial discrimination and of apartheid and slavery as obligations erga omnes. And I think it is possible that the court made this remark in passing, simply as sort of an apology for, its prior approach in the Southwest Africa cases. But in any event, this idea that obligations erga omnes protect important rights was picked up again by the court in its more recent case law. So, for example, it was on this basis that both advisory opinions in the Wall and the occupied Palestinian territories described certain obligations under international humanitarian law, and also the obligation to respect the right of self-determination as obligations erga omnes. And similarly, in the treaty context, in Belgium versus Senegal, reference was again made to the rights underlying relevant obligations in the Torture Convention to justify their characterization as obligations erga omnes partes. And in contrast, no such reference was made in the Gambia versus Myanmar, for example, and similarly, no mention is made in the climate change advisory opinion. So this second approach has in practice been applied quite selectively, and it's also often been applied alongside the first approach to justify this idea that states share a common interest in compliance. The third approach is to define obligations erga omnes and erga omnes partes by their non-bilateralizable or non-synalagmatic structure of performance. And so in other words, the conduct and performance of an obligation towards one state necessarily satisfies the performance of the obligation towards all the others. And similarly, the breach of the obligation towards one state necessarily amounts to the breach of the obligation towards all the others. And so what this implies is that in many cases, no state may actually be injured by the breach of the obligation. I think it's important to say that nowhere has the ICJ expressly adopted this approach. And only Judge Studi has taken the view that obligations erga omnes are, in his words, not capable of being owed bilaterally. I think this omission to engage with this approach from the court is quite surprising because it seemed to be the dominant view within the ILC. And so members like Special Rapporteur Aranjo Ruiz specifically rejected this contrary idea that was the importance of the underlying rights that characterized obligations erga omnes. And Special Rapporteur Crawford also sort of hinted at this approach instead. But this third approach is nevertheless seen in some of the court's reasoning, specifically in relation to obligations erga omnes partes contained in certain treaties. So in Belgium versus Senegal and the Gambia versus Myanmar, the court recognized that the breach of certain obligations will not necessarily cause injury to any other state. And so if these obligations were not defined as obligations erga omnes partes, there would be no state withstanding to actually enforce them. And so this reasoning could have actually applied quite easily, in my view, to the climate change context as well. But it's curious and, in my view, also sort of regrettable that the court didn't actually engage with this line of reasoning in the climate change advisory opinion. So these are the three broad approaches of the ICJ, and they all give rise to different consequences, which we might also describe as problems, potentially. And I'll just set out some of the main issues that I identify in the paper. The first problem is simply the inconsistency with which these different approaches are invoked, which leads to a lack of predictability. And it's not clear from the case law whether the court sees any of these approaches as sufficient to actually support the character of an obligation as erga omnes or erga omnes partes. And so which approach or combination of approaches is used has a bearing not only as to how widely or narrowly these categories of obligations are understood, but obviously then also for the question of standing to enforce them in different ways. So the first approach, which invokes the common interest in compliance with relevant obligations, is most frequently used by the court, and I think is also therefore likely to stay. I think the problem with using this approach alone is that most multilateral obligations are likely to quite easily satisfy this requirement. And so unless a multilateral treaty itself imposes any further qualifications on the right of states parties to standing for enforcement, I think the first approach alone would imply a very wide right of standing. And so to avoid this, one suggestion could be to combine this first approach with either the second or the third approach. So the second approach, which defines obligations erga omnes and erga omnes partes as obligations protecting important rights, comes with its own challenges. So in particular, how do we actually decide which rights are important enough so as to justify the character of an underlying obligation as erga omnes or erga omnes partes? And I think part of the problem arises from the fact that the court has made very clear that its various references to the importance of these rights are not references to the peremptory character of the norms from which they arise. And so when the court refers to the importance of the rights protected by relevant obligations, it must be referring to some other assessment of importance. And so this is not only a highly subjective exercise, it's also likely, in my view, to give rise to further confusion between these categories of peremptory norms on the one hand and obligations erga omnes on the other hand. So I think there are good reasons to be quite skeptical of this second sort of rights-based approach. Another possibility is, of course, then to combine the first approach with the third approach, which recognizes that breaches of certain obligations will not give rise to injury on the part of other states. And so writing before the climate change advisory opinion was issued, I argued in the paper that such an approach would necessarily include obligations for the preservation of global commons, whose breach would not tend to injure other states as obligations erga omnes or erga omnes partes. And in the advisory opinion, interestingly, this is sort of the outcome that the court seems to endorse. But the difference is that the court has done so only by reference to the common interest in compliance with these various obligations, and omitting any reference to the non-synallagmatic or non-bilateralizable structure of their performance. So just one final point to end with. So when it comes to obligations contained in multilateral treaties, which advance common interests, according to the court hasn't actually explained how to assess which obligations contained in these treaties are obligations owed erga omnes partes. And to do so will, in my view, require something more than simply a reference to the common interest, which is typically articulated in the preamble to these treaties. And so beyond the question of which obligations in these treaties are actually obligations owed erga omnes partes, I think we should also be looking to the future, especially a little bit more skeptical of using this first approach alone, so referring to the common interest of states alone, which is perhaps too blunt a tool for addressing the various conceptual challenges that the court will inevitably have to deal with in the years to come. So I'll stop there. Thank you very much, and I look forward to the discussion.
Well, thank you very much, Priya. So now's your opportunity to formulate questions if you haven't already formulated some already. I think as with yesterday, volunteers will be helping out by bringing the mics around. So we have two questions. One here, Mike. Oh, actually, yeah, if you want to go first. Yeah, Mike.
Okay. Thanks everyone for your presentations. So I had one question to Veronica and Faye. Do you have a prescriptive or a normative take then? So how should the ICJ engage responsibly with treaty monitoring body interpretations? What level of deference or what other approach would you suggest? And then for Hoon, really interesting. It seems a little bit problematic to me to describe an advisory opinion request that others then claim is circumventing the consent requirement, or is maybe just posing a very broad, highly politicized question to the court as an abuse of process in itself. Because as you suggest, there is this suggestion that abuse of process needs to have malicious intent in some ways. So I wondered if it would make more sense to focus on the process of obtaining the advisory opinion request in the first place. So maybe, for example, an advisory opinion request that's been fraudulently or corruptly obtained. So for example, if a state is going around the General Assembly paying people to vote in favor of the resolution, or is circulating a fraudulent document, I mean, these might seem a little bit far-fetched, or maybe not so much, but in some ways that much more limited scenario seems to me like it would maybe fit more squarely within the idea of abusive process. So I'd be curious about your thoughts on that. Thanks.
Hi, my name's Stefan. I'm a PhD student at Bocconi. I have a question for Veronica on the admissibility jurisdiction point in Armenia, Azerbaijan on CERD, and if you have any thoughts on that and how that shapes into your analysis, if at all. And I have a question for Priya on the role of object and purpose to identify the common interest in the treaty context, where I think you can make a claim that object and purpose is a normative exercise in of itself when we're making an assumption of whether rights and obligations in a treaty are more important than others when we say, when we identify, any treaty having an object and purpose, and how that in of itself normative exercise impacts any other general framing. When we talk about the importance of the rights involved in a treaty, we can say, is that actually separate from a common interest approach, or is that part of a common interest approach? And how, when do these different approaches differ, or where are they part of a whole? Thank you.
Thank you. Thank you everyone for this very interesting presentations. So my first question is to Hoon. So I wrote down your parameters. You said wrongful invocation of procedural rights and excessively individualistic claims and the malicious motivation. And I think it kind of follows from also what Mike just said. It's very difficult to prove malicious intention, and then it's also will be very difficult for you to prove wrongful invocation, and if you could define that, and also the excessively individualistic claims, especially in the context of an advisory opinion rather than a contentious case. So it has been difficult for these claims to see any kind of recognition by the ICJ in contentious cases. I think arguably it's much more difficult for them to obtain something in advisory proceedings. And my question to you is not only going more into some detail about the specific parameters, but also, do you think it's desirable for the court to find an abuse of process, or this circumvention that it does without referring to it might be more preferable in given that it's very difficult to prove these things and will embarrass state or the organs requesting it, and all of these difficulties that you can encounter when you claim an abuse of process or abuse of rights. And then to Priya, I found the analysis very interesting. My question is, we always have this problem with the ICJ when we're trying to identify what is, how it justifies its decisions, whether it can say, is this customary law, is this a general principle? The court tends to never provide detailed reasoning or theory behind this. And I think in justifying Erga Omnes and Erga Omnes Partes, it just follows the same route of not saying more than necessary. And I'd like to ask you, for example, do you think that this is a case of judicial economy? Should it go further than needed to justify and provide a more thorough analysis of synallagmatic, non-synallagmatic, or will this bind it in a way that it doesn't want when it doesn't have to enter into this kind of discussions? Yeah.
And then I think that'll be the last for the surrounding questions.
Morning, everyone. My name's Naomi Hart. I'm at Essex Court Chambers. Priya, just a really specific question for you, just probing on your point that your third theory about Erga Omnes obligations arising where no state is harmed, and you said that you thought that could apply quite naturally in the climate change context, and yet we know, of course, that virtually all states are harmed by failure to comply with climate change obligations, and there are certain states that are really at the forefront of that. So just trying to probe exactly why you say that your third theory would be appropriate in the climate change context. Is it because this would be a way of circumventing issues with proving causation of harm? Is that what you're really driving at? Or yeah, just trying to probe exactly why you think that third conceptualization would fit in the climate change context.
Thank you very much. I think we'll start with Priya and then move down and then move to the next round. So,
Thank you very much for the interesting questions. Stefan, first, the question on the use of object and purpose to identify the importance of rights. Is this a separate approach or part of the common interest approach? So I would generally, and maybe cautiously, put it within, the common interest approach, but I do think there is a key difference. So up until the Gambia versus Myanmar, in my view, what the court was doing was essentially engaging in this treaty interpretation exercise, invoking the object and purpose to say that the state's parties shared this common interest, and then that justified standing, even where there wasn't any express provision of standing. And I think this is somewhat more palatable than the generalized sort of references to common interest, because at least it's taking place within the framework of treaty interpretation. And as you said, the difficulties or the subjective sort of nature of this object and purpose analysis applies equally here, but it doesn't just apply here. It applies pretty much everywhere. And so I don't think it gives rise to particular issues here. And I think the climate change advisory opinion in some ways kind of blew this reading of what the court was doing out of the water in the sense that now it seems that any obligations that protect common interests can give rise to standing on the part of non-injured states. And that is quite a significant thing, especially as now the court has recognized standing even in the context of customary international law obligations. So I see them as different. I think the court has sort of just analogized across these two processes and now suggested that, yes, just common interest in general. And I think in a way, that's what the paper is trying to get at, that, just invoking the common interest in this very generalized fashion is maybe not enough. And we need more specific sort of reasoning. Martina, I mean, of course, I completely agree with you, and I know that the court doesn't ever say more than it needs to. But I think a part of the problem, in my view, is that, yes, in each individual case, perhaps it's justifiable that the court hasn't said more than it should. But if we sort of look at all of the cases cumulatively, it does now seem to put the court in a very difficult position for justifying whatever it's going to say in the future. And of course, it's completely acceptable for the court to now say, well, yes, of course, we're fine with kind of opening the doors to these kinds of cases, and maybe it'll amount to a huge increase in caseload. But I still think, just from a reputational point of view as well, the court needs to have some very clear understanding of this. So just to kind of use an example, so Judge Studi, I think, is the only one who has expressly supported kind of both approaches in a way. So he has recognized that there are certain obligations, Erga Omnes or Omnes Partes, that protect important rights. But he also recognizes that there are certain obligations where it's really the non-bilateralizable nature of them that justifies their status as such. And so this is not to necessarily endorse his view, but just to say that he's at least kind of given some explanation for what he said. And so it's really just with a view to avoiding inconsistencies in the future that maybe it would be worthwhile for the court to think about it, even if it doesn't always give that much detail. And Naomi, thank you also for the question. It's a very good one. And I think in a way it goes to the very fundamental question of how we define injury. And so in the ILC, at some point, there was also this discussion of whether we should see all states as injured in the event of certain kinds of breaches, or should we see them as interested or affected in some other way? And of course, the eventual position was, to define injury in a more narrow way, and then to say in, Article 48 type cases that all states may be affected by a breach or interested in compliance. And so in a way, I actually answer your question in a different paper. So it's paper looking at interdependent obligations as obligations whose breach gives rise to injury on the part of all states. And I think some of the difficulties with climate change obligations are sort of set out there. But I think maybe just to answer your question in a more precise way, just because all states are affected by a breach doesn't, in my view, mean that there couldn't be an injured state or especially affected state. So, Pacific Island states, for instance, I think could still very well be especially affected by a breach and therefore injured states. So it's not to say that there wouldn't in principle be, but there could also be cases where there wouldn't in principle be an injured state, if that makes sense. So I have to admit, I did not think about this as solving the problem of causation, but I do think that's a really interesting way to look at it, and I'll have to give that a bit more thought. But I hope that answers the question.
Thank you for the question. I'd like to focus more on the situation in Palestine, which is quite surprising what happened there because the situation as you described it is a bit reversed. The ICJ advisory opinion was issued in July, while the ad hoc report was issued in August. And the ICJ, it did take into consideration the reports of the CERD committee in its regular reporting system on the situation in Palestine. The surprising thing that happens is that in the CERD proceedings, the ad hoc Conciliation Commission does not even mention apartheid in its report. And that's a bit alarming for the main reason that Palestine's petition back in 2018 was premised on apartheid. Palestine spent more than 50 pages arguing why the situation, why an apartheid regime exists. And it's really a pity that the Commission did everything within its power to engage Israel and make its good offices available and convince it to participate so that it can ensure the amicable character of the procedure, but it did not address one of the main questions posed by Palestine. So in that case, it's reversed, it's the other way around. CERD didn't take into consideration ICJ. I mean, ICJ's pronouncements on apartheid are again very limited because it simply said that a violation of Article 3 takes place, but it didn't really distinguish between racial segregation and apartheid. And in the different opinions of judges, we can see why it chose not to answer this question. But for CERD, it's really surprising because even consensus-wise, if I'm not mistaken, the members in the CERD were way fewer. They were either 5 or 7. I don't remember the exact number. So even consensus-wise, I mean, they could have at least made it one slight comment, and they didn't.
Maybe after her being first.
Just go down.
Okay. Okay, thank you for very insightful comments and questions. And with regard to the first opinion, the suggestion, I think it's very interesting to focus on not only focusing on the like a proceeding stage, but also focusing on the pre-proceeding stages like that. I think when it comes to the that suggestion, it will be more meaningful when I apply this to the rather than ICJ, but to the ITLOS. Because in the ITLOS, advice opinion proceedings as a tribunal, there are some kind of those kind of things like establishing a certain international organization or agreement only for the purpose of raising an advisory opinion request. So yeah, thank you for that suggestion. But at the same time, it comes with mind that I'm not sure whether that those kind of things like a robbing or like a paying for the making a public opinion, I don't think that is prohibited in international legal plane as well. I mean, well, when it comes to General Assembly of the UN and also in many international organizations, the governments do some voting trade as well. Like, we're gonna vote for your ideas, and also then next time you may like. So I'm not sure whether that those kind of interaction is totally prohibited under international law. So that is my first point. And with regard to the second question, I think that this one is also shared with Martina's question as well. So actually, that is my intention, to make it difficult to apply in everyday cases, because when you frame or blame a certain case as an abusive process, well, we all know that the term abusive process is very provocative. So it has a certain side effect, like overshadowing and also make some prejudice against certain cases. But when I show my the list of the alleged abusive process cases, I told that I intentionally exclude all the academics claims or argument because, yeah, I mean, quantitatively, there are many more volumes arguing or blaming a certain case as abusive process, but most of them did not provide any certain criteria or how to define this one as that one. So in my perspective, they just use the term abusive process as a mere rhetorical expression. But But compared to that, when it comes to state parties and the judges within the court, I think that they will use this term as more gravely. So in that aspect, I focus on the only 4 cases. And with regard to the 3 components that I suggest, the first one is a wrongful invocation of procedural right. The second one is malicious intention. The third one is injury. Well, I think that the first one is the most clear one to define. I mean, so when it comes to the advice opinion in the ICJ, the first one can be easily checked whether that organ is authorized to make a request, or whether that question is within the mandate of that organ as well. So I think that the first one is very easily fine. And when it comes to the General Assembly as well, of course, there is no case yet, but we can imagine that if General Assembly raise a question only with regard to the purely, I don't know whether it can be exist or not, but purely political ones, or purely concerning that like domestic matters, then we may simply find that the first component can be met, that that request is wrongfully invoked. So, with regard to the desirability, well, I think yes. I mean, I'm not trying to say that the ICJ should be more restrictive to say this one is visa process or not, but I'm not trying to say that. But at least the ICJ it'd be desirable to deliver a certain criteria to determine which one can be determined as an abuse of process, because I think that one is also the function of the International Court, especially the International Court of Justice. Thank you so much.
Thank you for the question. I will first address Stefan's question and then comes to Mike. Actually, thanks for the question, because it allows me to dig a little bit deeper into the assessment of jurisdiction ratione temporis, especially under the Azerbaijan versus Armenia case. Well, the ICJ, according to me, made some patchwork of reference to previous judgment while avoiding like citing, for example, Ambatiello's case, which like it seems like to have taken into account kind of reversing or distinguishing, I don't know, for example, previous Mavromatis posture or Bosnian genocide cases. Here, I think that the individual opinions of some judges shed some light on the court approach, because, for example, I remember Judge Yusuf individual opinion, which, of course, like was, according to me, right in differentiating the Azerbaijan versus Armenia issue from the Bosnian genocide case one, for example, because in Bosnian genocide case, the issue of jurisdiction ratione temporis was mainly connected to question of state succession to the treaty, like replacing former Yugoslavia, participation in the genocide convention, while Azerbaijan versus Armenia refers like to the application ratione temporis of the compromissory clauses in relation like to events occurring in Nagorno-Karabakh before the entry into force of the CERD Athens for Azerbaijan. So it kind of conflated some aspects. Also, I mean, the outcome was quite predictable in my opinion, because like, for example, I remember Judge Danagyu in Belgium versus Senegal mainly made clear that the question of jurisdiction ratione temporis, or the application of the treaty between the two parties, maybe it was not a question for the jurisdictional phase, but maybe warrants closer examination at a later phase of the proceedings. Here, like jurisdiction ratione temporis has been like resolved by the ICJ, mainly in a very facet way, because like, for example, I'm thinking about Shabda-Rosen quote that according to which like jurisdiction ratione temporis can be a known problem insofar as jurisdiction ratione personae and ratione materiae is already solved. And here there is another aspect that, of course, I mean, we all know Article 28 of the Vienna Convention providing for the non-retroactivity of treaties between the parties. But here, I mean, it really depends, according to me, on which jurisdictional basis is invoked by the applicant state, because, like, for example, jurisdiction ratione temporis is a problem that, for example, is posed by Article 36, paragraph 2 of the ICJ statute, and we know that, for example, parties used to attach like declaration claiming for the non-retroactivity of the ICJ jurisdiction, while in the like treaty compromissory clause situation, again, the situation could be a little bit less problematic, but here again, it all revolved about the strange, according to me, reconstruction of basically some sort of two-tier CERD-based obligation, because like it really depended on the qualification of the applicant state. For example, in the twin case, Armenia versus Azerbaijan, Armenia deliberately qualified itself as both as a parens patria for its citizenships, or acting in a sort of diplomatic protection fashion, and both as an omnes of the convention. So that really ties to my close point, like in order like to overcome this problem, it's better for the applicant state to, as Judge Charlesworth also pointed out in her individual opinion, to double qualifying in order to overcome this problem, because otherwise I'm afraid it will be a trend of the ICJ jurisdiction. And coming to Mike, well, that's actually a good question. I will not expect the ICJ to engage meaningfully with the CERD committee, basically because, as in Azerbaijan versus Armenia, the ICJ made quite clear that the two procedures are different, although they are connected, because like it's Article 22, like verbal tenor, like it's saying that it's there. But what strikes to me is that, for example, in all CERD-based cases, the applicant state make quite clear reference to the CERD committee, CERD general recommendation. And for example, in Ukraine versus Russia under the CERD, at least the ICJ justified its posture, but in Qatar versus UAE, the ICJ justified its posture vis-a-vis the General Recommendation number 30 of 2004, disregarding it, okay? Like, it's there, okay, thank you for the applicant state to raising the point, but we are not, like, following the line. In Azerbaijan versus Armenia, you can see a clear trend of applicant states not referring to the CERD committee general recommendation. So I would expect at least the ICJ to treat CERD committee's work or general recommendation as evidence and interact with it. It's very interesting, although we all know that, for example, the Ukraine and the Netherlands versus Russia judgment came after the Ukraine versus Russia CERD-based litigation before the ICJ. It's interesting to see again how the European European Court of Human Rights did interact with the ICJ findings. I mean, in Ukraine and the Netherlands, it did not interact in Ukraine versus Russia re Crimea, we know. But at least there is an interaction. At least like we know what the rules are for like judicial dialogue, and we can see it in the judgment. Like I did not expect the ICJ to engage, but it would be desirable at least, because like we have one convention, we have two like monitoring bodies. If we consider the ICJ as monitoring the application and interpretation of the treaties, so I would expect some uniformity, because otherwise, I hopefully think that the CERD interstate communications procedure can be a more viable solution for states, although we know that the recommendation is not binding. So like it's for states to choose which strategy basically to put at play and to put at the test in order to like gain the outcome they desire, because like it really depends. We saw yesterday if they want to raise like a political dispute before the bench, if they want to have a redress, if they want like to raise some spotlight on some situation, and that really depends. But I will expect some dialogue, even negative one, but dialogue.
Thank you very much. I think we have several questions already. So I think first was Cecily, then.
I just had a question for Priya. So I wondered if you've considered how this goes to my interest in transnational criminal law, how transnational criminal law treaties contain a combination of multilateral and bilateral obligations. And so in this context, it's indeed not enough to say that there's a shared interest in states complying with certain obligations. You have to also look at whether they're indeed multilateral or bilateral, because the obligations concerning mutual legal assistance and extradition are bilateral, whereas the obligations concerning criminalization, for instance, those are multilateral, and also the failure to comply doesn't result in an injured party. So I think that these treaties are actually really useful for maybe your point that it's important to do more than just identify a shared interest.
Thank you.
Okay, Christian Tams, Glasgow. I have one question for Veronica and Faye and one for Priya. So for Veronica and Faye, you focused on the interactions substantively, so different types of interpretation, different attitudes. And my sense was that there's a bit of chaos because there's CERD, which issues opinions that you like or don't like. There's the ICJ that takes a view. So my question is, do you think the mess was created by the ICJ when it decided that prior recourse to CERD under Article 22 was not a requirement of seizing the ICJ? And do you think that was the correct decision, or would you have preferred, in retrospect, seeing the mess that you've described, would you have preferred a different approach where recourse to the ICJ is premised on prior exhaustion of a CERD committee procedure? For Priya, so it's pretty clear from your presentation how far we've come with respect to, let's say, Erga Omnes litigation or Erga Omnes Partes litigation. Do you think the time is right for the ICJ to say which obligations are not Erga Omnes or Erga Omnes Partes? And if so, which would you put to the judges as meeting that test of not Erga Omnes?
Thank you.
Thank you, Philippe Fontanelli, University of Edinburgh. I'm addressing Hoon, and I know how it sounds, but it's more of a comment than a question. I hope it's helpful. It might be uninformed. I think your first feature of abuse of process is somewhat like breach of a requirement or wrongful invocation, and you connect it to wrongful act, like a breach of a rule. And I'm wondering, do you need at all breach of a rule as a component of abuse? It seems to me that the notion of abuse does without the breach to begin with. It's abuse of a right. And I know it's tempting to fill it with some sort of other breach, but it might sort of erase the distinct use of the notion of abuse. And maybe one way in which this can work is that, yes, a breach might be in the picture, but a breach about something else, the injustice of which transpires towards the request in the way that maybe Mike suggested. But and it's my inclination, but I would start assuming that there's no breach to begin with, and the only rule or norm that is breached is the principle of abuse of processing. You don't need another one. Thank you.
Thank you. I think we'll take two more questions. I think there's one here and then one on the far side.
I'm Lou from the Lisbon Public Law Research Center. I will be quick. And first question I would address to Hoon, and about things you also mentioned, the 8 laws, because you mentioned abuse of process. Actually, those features you mentioned in those advisory opinions that ICJ barely rejected questions raised, saying the legal issues or political issues involved does not necessarily will bypass, like be a procedure hurdle. All those things the advisory opinion it's non-binding. Those features, I was wondering, like also just as mentioned, I asked a question about the notion of the abuse. So if we think the other way around, actually, if those things, it's a good use of the advisory opinions, especially like it's a non-legally binding, and also it's like the advisor opinion can address something it's involving those sensitive issues, because maybe states would not like to those issues, or would not so likely to be like settled in a contentious case. This is the first question. And second comment is also about, I think, one thing all those four speakers mentioned about, for example, I think the third speaker, it's very interesting that you compare that to like procedures. I think it's very nice approach. Then you also mentioned that it's not enforceable, and those this could be those disadvantage, but also I think this could those advisor opinions, they're non-binding on parties, but does not mean they have no legal effect. Just I remembered yesterday that Alison mentioned that the Victoria Wind in the advisory in the ICJ also play a function in other like legal proceedings before under the Hoon clause. And the third question is just Priya, very shortly, when you mean the coherence and the confusion, it's the collegial opinion of the ICJ, like benchmarking different cases, different opinions. Do you consider the coherence and confusions of judges' individual opinions? Like, for example, yesterday just mentioned by Sir Michael Wood, actually there's some really quite confusion in the own opinion of Chinese judge. Thank you so much.
Thanks, Millie Durham. I've got a question for Priya that's related to Christian's question, actually. For me, your approaches 1 and 2 are very closely connected because states have common interest in things that are important. And then, so can you think of an example of a common interest in something that's not important?
Thank you very much. I think we'll go same order again. So Priya.
Thank you very much. I'm at that point where I'm losing track of my written notes, which is dangerous. Thank you for the questions. So I'll just go in order. Cecily, thank you. I think you're absolutely right, and I have read your work on this, which I found very helpful as examples go. And I would tend to agree with your sort of division. So when it comes to things like mutual legal assistance obligations, those are in any event of performance bilateral. And so there's no real question of Erga Omnes Partes obligations there. Whereas when it comes to criminalization obligations, those are quite interesting because, as you said, there's not going to be any sort of injury arising from the failure to criminalize. And I think this is an interesting sort of subset of what are often referred to as kind of standard setting obligations for states domestically. And I think Sally's talked about this in her recent book as well, where these would, at least in my view, certainly be cases of obligations erga omnes partes because of the absence of any means of enforcement otherwise. But I do think that there's another subset that's a little bit more difficult that I try to tackle in the paper, but which I didn't mention in the presentation, because I think there is also a set of obligations that whose breach will sometimes cause injury and at other times will not. And Christian discusses this very well in his book, of course. So for example, when it comes to the prohibition of genocide, a state committing genocide against a group within its own population will not necessarily injure any other state. But of course, a state committing genocide against a group within the population of another state, that would give rise to kind of bilateral injury-based situation. And so I think in a way, this category is the most difficult because it's linking the nature of the obligation to the nature of the breach as well. And there's something about the factual circumstances that we use to then look back on and decide on the nature of the obligation. And this is very pragmatic, I realize, and it's not really satisfactory from a principled point of view. But looking at, a court like the ICJ, I still think that might be a useful line of reasoning for the court. And I share your view as well that a shared interest is often just not enough. And I've actually pulled up a quote from Crawford where he says, which international obligations are not in some sense established for the protection of a collective interest. So I think that makes the point quite well. Christian, also, thank you for that. A very good question. In some ways, I think it links to what I just said with respect to Cecily's question. So, there are some obligations that are always going to be bilateral in their performance. And so I think these would necessarily be excluded, even if ultimately there is some sort of common or shared interest that they lead towards. But as I said, again, I think there is this difficult category of obligations where sometimes a breach could give rise to injury, but in other instances, the breach of the same obligation would not give rise to injury. And so I think there remains this sort of gray area between obligations which are erga omnes and those which are not. And I think this is also a discussion that Judge Ad hoc Kress makes quite well in the context of the Gambia versus Myanmar. And of course, I wish, for my own work that he had elaborated even further, but he makes this distinction, I think, quite helpfully, but without necessarily, giving kind of the full view. I think one problem, though, that arises is the idea that even if there is an injured state in the event of a breach, non-injured states to which the same obligations are owed would still retain standing. Now, the court hasn't said this expressly, but it does seem to be the view that it's taken in the Gambia versus Myanmar preliminary objections decision. And I wonder whether this is necessarily a good thing, because again, looking, at things like judicial economy and just what is pragmatically useful for the court, it may not necessarily be useful to say that if there is an injured state that is entitled to bring proceedings, then other states to which the obligation is owed would also retain that entitlement. And if I recall, I can't remember who it was, but one of the members of the ILC pointed this out and suggested that the former would exclude the latter. But it seems that at least in Gambia versus Myanmar so far, the court has suggested that both would continue to exist in parallel. So, that's one sort of potential issue there.
Just on time.
Yes. Oh, I can stop. Yes, sorry. Lou, I can be really quick. So I haven't looked at it specifically, how, judges may be inconsistent, but I did note Judge Shui's kind of change in position, among other judges' views. But I can't think off the top of my head of any other judges that have sort of shifted so significantly. And Millie, I would just, tend to agree. I think, so the court has tended to refer to the importance of the rights, but we also have some individual judges referring to obligations erga omnes as protecting important values of the international community. And I think this sort of vague language just adds confusion, and I'm not sure it's very helpful, is the short and brief answer. Sorry about that. Thank you.
Just ask everyone else to keep the answers to a couple of minutes, 3 minutes each.
Yes. Thank you. We'll start with the second observation. So yes, it's true that the rulings are not, strictly speaking, binding. And this means that if Israel continues its presence in the occupied Palestinian territory and generally its policies, this doesn't mean that actually not abiding by the pronouncements in the advisory and conciliatory proceedings isn't a self-standing wrongful act, while not abiding by a judgment is. So, however, their contribution to resolving the dispute is the following: that they somehow have reconstructed the substance of the dispute, and they have brought the issue of apartheid within the very core of the dispute. And in fact, following the ICJ ruling, in its resolution adopting and endorsing the opinion, the General Assembly specifically requested the establishment of a specific organ that will deal with apartheid claims in Palestine. So this shows a slow and steady shift that hopefully, following the case of Chagos, it will also contribute to settling steadily and slowly the dispute. Now to the question posed by Professor Towns. In the absence of a clear provision that within the treaty that these two mechanisms, actually appealing to the CERD is a prerequisite to invoke ICJ jurisdiction, I would say that such a construction would erode the free choice of means states have when settling the disputes. And also such a construction of the institutional relationship between the two organs is a bit problematic to me, because it raises further questions as to, okay, states need to go first to the CERD, And then what will be the question brought before the ICJ? Will the ICJ act as an appeals chamber to what happened in the CERD proceedings? And if the ICJ adopts, as it does, a different point, does it mean that CERD needs to follow the ICJ judgment? So I think such a reconstruction of the institutional relationship between the two organs raises very difficult legal questions. So I don't think it's, in my opinion, a good one.
Yeah. Thank you for the comments and the questions. So when I decided to do this research, the first task is to how to set up the relationship between the violation, which is breach of the obligation or rules, violation, misuse, and the abuse. So I said that the misuse has the bigger diagram. So this includes both lawfully and unlawfully use of certain rights. And then inside that there is a violation, and within the violation, I put the abuse in that way, because in my opinion, I mean, of course, there seems quite a circular logic, because when there is an abuse of right, of course, it may result in a violation of that relevant rules, but it's hard to imagine that when a state abuses its right, it cannot be expected that that state has properly exercised those rights. So in this research, I how can I conceptualize the abuse as the smallest part between the abuse, misuse, and the violation. So yeah, thank you for the comment. So and also with regard to the three components, actually, they are not just from out of my mind. I mean, there are so many not public international court of tribunal, but for example, like ECTHR, like HRC, the proceedings or UNCITRAL arbitration, there are so many rules concerning the abusive process. And for example, like the HRC application, there is a rule in the convention that in this case can be regarded as an abusive process, and that condition is actually required some kind of conditions to raise claims against the HRC. Or so in those analysis, I draw some commonly applicable component. And when it comes to the use of the system, yeah, I agree that it's very good. But the point that I'd like to raise was we should be cautious not to abuse the abuse of allegations of the abuse of the system. Yeah.
Thank you, Professor Thoms, for the question. It's a tough one, but I would like to stick to like the recent Azerbaijan versus Armenia case. That was interesting because, like, I mean, we all know like the preconditions game as like alternative means of prioritizing the ICJ. This has been like said in Qatar versus UAI, like reversing some sort of the regrettable outcome of Georgia versus Russia in 2008, preliminary objection phase. But I found it interesting because to me, the answer will differ according to which angle we choose like to adopt. For example, as I stressed in the presentation and as I stressed in the slide, Article 11 of the CERD, providing for the interstate communications procedure, always talk about dispute between the two parties. And that's the same word we are used to use, again, for referring to contentious cases before the ICJ. They are dispute. And then the question of the questions arise. What is a dispute for the purpose of CERD? And does the answer should like be differentiated according to the mechanism we are triggering? If we like look back in the ICJ jurisprudence, also PCIJ jurisprudence, we know that, I'm citing Mavromatis again in this case, the PCIJ described a dispute as a conflict of legal views or of interest between the parties. This could be either before the ICJ for CERD purpose and either before the CERD committee for CERD purpose again. So according to me, if we are like looking at the procedure, at the conflicting views of the parties, there can be some correspondence. But if we look at the outcome, I mean, does the outcome characterize the dispute? Does the outcome is a genuine necessary requirement to define a dispute? I mean, according to the bindingness or non-bindingness of the outcome, is the dispute right there or not? Of course, I remember an article from Professor Zimmerman on this issue, and he was advocating for some sort of mechanism. Feya was referring to imagine the prioritizing of the CERD committee as precondition for the subsequent ICJ disputes, creating some sort of hierarchy. But the reality is that I found these two procedures to be very different, not only in the outcome, but also in the main aim, regardless of the using of the term dispute in the CERD convention, because we all know that the CERD committee, of course, issue recommendation, but it does not held a state responsible. So that's the question. And the ICJ, of course, we know, should end the contentious cases before CERD or under other convention, Erga Omnes Partes Convention, as probably defining the responsibility of the states or not. So they are parallel ways. Again, I think it all depends on what state are aiming to obtain with this dispute, but they are two sides of probably the same coin, which is CERD convention, but it can be it helps both the recommendation of the CERD and the ICJ judgment can serve different purpose, but for reinforcing the CERD convention enforceability in general. So that's my take.
Thank you very much, and thank you very much for some very detailed, quite very good questions. And I just want to say, you could all join me in thanking our wonderful panelists. And I think there'll be a coffee break now until 11:30, when we'll reconvene for the next panel, which will be the ICJ in time. So thank you.